Under the attorney-client privilege, you can tell your lawyer anything in confidence, and he can never, ever repeat it to anyone, no matter what. And this continues even if he's no longer your lawyer. This is a powerful, powerful tool for you to use whenever you need to hire a lawyer. Hello folks, I'm Andrew Williams. Welcome to another edition of the Fedora Lawyer. This is your source for legal information. Now, most people have heard of the attorney-client privilege, but they don't really understand how it works or how really powerful it is. The attorney-client privilege means any confidential communications between you and your lawyer are barred from being disclosed to anyone ever. This way, you can speak freely to your lawyer without fear of any repercussions whatsoever. The privilege extends to all communications between you and your attorney, and this includes emails and text messages as well. Since you have this important and powerful protection, it's always good to tell your lawyer everything there is to know about your case. Your lawyer is the only person in the whole wide world who is bound by law to keep your secrets secret. Holding back information from your lawyer can only damage your case. You don't want your lawyer to learn about some damaging information in the middle of a trial that you could have told him about months before. If your lawyer knows about it ahead of time, he can be prepared for it and diffuse it maybe, or maybe even keep it out of evidence altogether. But you gotta tell him. So when does the attorney-client privilege start? First of all, you don't really need to have an express written formal contract between you and your attorney. At the same time, you can't just ask a lawyer friend of yours a legal question and expect that to form the attorney-client privilege either. There's lots of factors that go into establishing the attorney-client privilege. However, in most cases, if you go to a lawyer's office for the purpose of seeking legal representation and have a meeting with that lawyer, that meeting and everything you say in that meeting falls under the attorney-client privilege. And that applies even if you don't end up hiring that lawyer. Whatever you told that lawyer in that meeting is going to be privileged. Now, once the attorney-client privilege is established, there are some limits to it. For example, the privilege doesn't cover a situation where what you tell your lawyer might end up hurting somebody either physically or financially. Also, the privilege doesn't exist if you ask your lawyer to commit a crime or a fraud or to help you cover up a crime. Remember, you can tell your lawyer that you committed a crime in the past, and that will be privileged. But asking him to help you cover up the crime that you committed, that's not going to be privileged. Also, the privilege only goes to what you tell your lawyer, your communications to your lawyer. That's what's privileged. It does not extend to physical things like evidence, like you can't shoot someone and then take the gun to your lawyer's office and ask him to hide it for you. That doesn't count either. And finally, the privilege continues even after your lawyer is no longer your lawyer. And most importantly, only you can waive the attorney-client privilege. Your lawyer can't do it, nor can anyone else. It has to be you. However, it's very unlikely you would ever want to do that. Okay, well, I hope this information was beneficial in helping you understand the attorney-client privilege. If it was, hit the like button for me. If you're interested in legal matters of this sort, you might be interested in either of these two videos as well. I plan on making lots more videos on all sorts of legal topics in the future. You can also visit my website at andrewwilliamslaw.com. For now, this is the Fedora Lawyer signing off.